My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public, so please subscribe to our channel. Today we're talking about custody. How does one get custody in a situation where the court made an order, and let's say gave custody to both or gave custody to X, and now you feel that the full custody has to come to you? Maybe the child's being threatened, maybe the well-being of the child isn't being pursued, maybe there's abuse going on. How does one do that? Well, number one, you should consult with your attorney, because consulting with your attorney will help you gauge whether or not the facts that you now have at your disposal are enough to convince the court to revisit custody. You know, the court doesn't like changing its own orders, okay? So you have to keep that in mind. If you're going to ask the court that gave one order to switch it, the court's going to need some compelling reason. And the compelling reason is going to have to be something that shows a significant change in circumstances that the court didn't consider before. Had they considered, had they known then what we know now, they wouldn't have given custody. And you've got to bring that before the court. In order to do that, you got to run it by your lawyer, because he or she's going to be able to tell you, you know what? I'm hearing what you're saying. I think this will be enough for the court to reconsider it. Doesn't mean they'll give it to you, but at least they'll reconsider. Or the lawyer may say, I hear what you're saying, but I regret to inform you that's not a basis for changing custody. You've got to show a significant change in circumstances. It can't just be that the kid got older and decided to rather live with mom. That's not going to cut it. When the court grants the custody order, it does so knowing full well that the kids are going to grow up, that there will be reasonable changes associated with that, and the expressed preference of the child is only one of a dozen factors. There are 11 other items the court considers in determining change of custody, and just the mere preference against the other factors result in the court changing custody. So your lawyer can tell you if you're on the right track. Now, if you are on the right track, if the lawyer says, you know what, there is something going on here that the court would want to consider, like, for example, the custodial parent has taken to alcohol or drugs, and it becomes an important thing, and the court's going to want to know that, and it's a change in circumstances, and the court would not have given custody to a drug addict had it known. It's good enough to say those things, but ultimately, you can file a motion, the court can say, okay, I'll revisit it, but at the end of the day, you're going to need to prove what you're saying. And just your own feeling that when he picked up the kids, he seemed like he might be intoxicated, that is not going to cut it, because you're not a toxicologist. You're not an expert on these things. You're going to have to show legitimate proof. I've had situations come up where clients have come into the office when I tell them, get proof, and they will show me lines of cocaine on a table at their ex's house. Clearly, this is going to be something the court's going to be very, very concerned about. I've had situations where people will call me up and say, you know, the child is doing terrible, and they'll show me that under the custodial parent's watch, in the last half a year, the kid has missed school 76 times. That's a real significant departure from what the court thinks is normal behavior, and the court's going to want to know about that. That level of absenteeism is something that the court's not going to like, and will probably consider a change of custody because of it. But the point is, you're going to have some evidence to support what you're saying. So documentation is the key. If you have any questions about your case, reach out, and we'll be glad to help you out.